Okay. So thank you so much, Andy. I really appreciate it. I'm trying to. There we go. All right. So thank you so much for joining me. I really appreciate it. Um, can you can you give me like your first and last name and your title?
Andrew Finko. I'm an attorney.
Okay. And what kind of law do you specialize in?
I have a concentration in election law. That's the seasonal part when elections come and go. And in between that, I do litigation where I represent people getting sued for breach of contract and a couple, on and off a couple cases for some construction issues.
Hmm. So this is pretty much like a really busy season for you, kind of smack dab in between two election cycles, would you say?
Yes, yeah.
Yeah.
And the upcoming is gaining so much popularity. I think with the upcoming Chicago is gaining a
Yeah.
lot of popularity because of some interesting mayoral candidates that are coming out of the woodwork.
Yeah, they're coming out of the woodwork. So just to share with you all, Andy, when I ran for office in 2019 for Chicago 20th Ward Alderman, Andy was my attorney, my election attorney, and not only did I challenge people, I was challenged, and it got pretty hairy at one point. Um, yeah, it was really scary. Almost didn't make the ballot, but I think between Andy and having a very empathetic election judge there, the challenge was dismissed. So we saw this a lot in the Chicago elections, Chicago school board elections, where a significant number of candidates were challenged, and that's something that people always face. People that run for office. So, can you just give us like a explanation of like what does it mean to be challenged as a candidate?
Illinois has its own election ballot access scheme, and that ballot access scheme includes an objection process where the election code presumes that some voter from the district will check the candidate's signatures, review the paperwork to see if it's proper, and then file an objection before an electoral board. It's the reality is that it's always going to be either the political party or opponents that are doing the objection. The voter is a nominal name on a piece of paper that never shows up. The lawyers run the objection process. So it's a very antiquated system. Most states have many, not I don't know about most, but many states have gone to a more modern and neutral approach where an election authority would check if there's proper paperwork, and then if there isn't, give the candidate some time to get it up to speed. But Illinois has a very challenging process to overcome in order to reach the ballot, and that's unfortunately it's very much in favor of the objector because the objector does not need to show up. The lawyer does everything. And one person or two essentially can negate the will of hundreds or thousands of voters on a piece of paper. The voters sign petition sheets still. A lot of states have electronic signing online and they modernized their system. Illinois is still using ink on a piece of paper the way it was in 1900. So that's just a general summary. I mean, there's the if you want
You
more
could,
details, I can get you more
yeah, you could give
detail.
me like what are some of the reasons why people petitions are challenges, like on what grounds?
Okay, so the goal of an objection is to control who's on the ballot because if a person is not on the ballot, they will not be elected, obviously, and the other people who are on the ballot are the ones who are pre-selected or more likely to be on the ballot and going to be elected. So the goal ultimately is to control the ballot. The ways that that is accomplished is through a review of the election code to see if the election code requirements were met by the candidate. And the election code has a lot of obstacles. The obstacles are for ballot, to get on the ballot include things like, well, the number of signatures, that each page has to have a certain heading and a certain part at the bottom that's the circulator's affidavit, that if those technical things aren't in compliance, there may be a chance that that could be a reason for removal. There is a requirement for a statement of economic interests for many office. That statement of economic interest has two forms. One is for the counties, one is for the state. And if a candidate uses the wrong form, that's a reason for disqualification. If the candidate fills out the form and turns that in with the paperwork, that's a reason for disqualification, because the form for the statement of economic interest has to be filed with the Secretary of State in Springfield. And they don't have an office in Chicago. They don't accept the form in Chicago, even though they have an office here. Or the other form that has to be filed with the counties. So that's another obstacle, that you have to now turn in the receipt with your paperwork. And if you don't turn the receipt in, that's a reason for getting knocked off the ballot. There's also the obvious part about ink signed signatures on a piece of paper that may or may not match up with what the original voter registration record is. So, signatures don't have the same meaning right now. Signatures aren't used. People don't write with pen on a piece of paper very often. Most people don't use paper checks. So there's not a lot of use for the handwriting. And so a lot of times the other problem I have with the handwriting is most people are not taught for the last 20 or so years, or 30, have not been taught how to write cursive handwriting. And the only time they really used handwriting was on some of their papers in their elementary school, where they would print their names on the top of the paper. So that's the extent of people's signature, creation, is printed handwriting. So that's no longer a valid method of identifying a person. And there's data that shows that it's no longer, reliable. But the other part is the other trick is that potentially the voter is in or out of the district. Well, Illinois has been gerrymandering districts forever. And those districts, if you look at them, are really messed up. They're going in and out and all around. So it's very hard for voters to sometimes know whether they're in or out of a district. And even candidates with maps sometimes you can get confused as to what side of the street somebody is in the district or out of the district. So that's another reason. The registration. So if somebody signs up for example, an address change on their postal service, their mailing address, there's some boxes that you can click. And if you're not paying attention, you could change your voter registration to the new address, whether it's temporary or permanent. Same thing, your driver's license, when you sign up, that can change your voter registration. Well, if you forget that, for example, okay, I signed up 2 years ago when I updated my driver's license, and then you move apartments, you forget to update your registration. Well, now it's sort of a limbo state because you're living at one address, but your registration hasn't caught up. So that's another reason to challenge and object to somebody. The election code is a little inconsistent, because the election code says voters within the district can nominate or sign up to get that person's name on the ballot. However, the election authorities, the State Board of Elections, City of Chicago, Cook County Clerk, all the different election districts, look at the address that's written on the sheet. So whether that person can be found at a different address, for example, they may have stayed at one address, but their permanent registration is in another. And for college, people who go to college is a great example, where they still have their parents' address as their permanent address, but they're living in another place while they're going to school. So they have two residences. I think it should be opened up that if a voter can be found anywhere in the district, they should be counted for that person, because all they're doing is saying put their name on the ballot. They're not. There's no other commitments or obligations.
Right.
So
Yeah, I think about I know there's a woman, she was running, well, she's still running for school board, and it was definitely something she had to go around and get affidavits. So there's an entire process that people have
Yep.
to go through if their signatures are challenged. I know when you mentioned a couple of things. Um, I circulated most of my petitions and I was challenged on my signature because I registered to vote 10 years earlier. So my signature was definitely different than how I signed the
Mhm.
petitions. So, and then also the next part of validating the signatures, we had to actually go downtown because you can only go access the signatures downtown. And we had to go line by line to verify each signature.
Mhm.
Um, in order to make sure I met the threshold. So it is very time consuming. It's labor intensive and it's costly too. So like how much does it run candidates to have to, especially if they want to hire someone like you with the expertise instead of trying to manage their challenge on their own?
Well, I mean, it depends on the amount of work. So I'll offer attorney fee based on the amount of work that I anticipate is going to be needed to defend the objection, and that could vary thousands of dollars. I mean, I've seen there was some candidates will charge, or some attorneys will charge the candidate tens of thousands of dollars. I've seen that reported on the candidates reporting with the State Board of Elections. The other part of the equation is that sometimes you need to hire notaries, like you mentioned, for getting affidavits. That's to rehabilitate a signature. And an affidavit is basically to confirm that says, yeah, I looked at this piece of paper that I signed 2 months or 3 months ago, that signature is mine. Yeah, it's changed because it's 10 years old or whatever, or it's changed because I was signing it while standing on a clipboard in a hurry. And so it's never going to be the same. Or like I think a lot of signatures now are digital signatures from the Secretary of State. So you're signing on a pad with a stylus. And that's a different feel and a different way of writing than it is on a piece of paper. So, it's going to be differences there.
Yeah. Something you also mentioned early is how this, I guess, impacts the will of the people. Can you talk more about how, being challenged is it a form of voter suppression?
That's a tough. I mean, I depends on the lens you're looking at it from. I mean, the people who are lodging the objection will say, "Oh, it's law. It's allowed under Illinois law." And so, because it's allowed, and I mean, laws are not necessarily all the for the best for the people. I mean, we had the great example that a friend of mine keeps reminding me about is that there was segregation of schools for a long time, and
Hmm.
there were 12 or 14 cases that went to the U.S. Supreme Court to say, segregation is wrong. We should not treat people differently. That everybody should have equal opportunity. So the Supreme Court said, no, we're not going to change things until Brown versus Board of Education. And finally, they realized, okay, well, maybe those old laws were not the right laws, and they changed them. So I think I think some of that is in play right now, where some of the laws are on the books. They are properly enacted, I guess, hopefully. I mean, there's a lot of question about whether the gut and replace laws that are enacted by the election code are lawful because they're not having the three readings, they're not properly presented, there's not the debate. Those are some concerns that I have seen. But we have to take the law as being valid until the Supreme Court or Illinois Supreme Court or the U.S. Supreme Court says they're no longer invalid. So your question of whether it's voter suppression or not turns on the ultimate look back in time to say, okay, well, were those laws appropriate or not? Currently, the election code allows an objector who is a faceless name on a piece of paper. And I say faceless name on a piece of paper because that objector has no obligation whatsoever. They don't have to sign the objection. They don't have to verify the objection. They don't have to show up. They don't have to do anything in the case personally because they have a lawyer who does all of the actions for them. So some lawyer with an unknown benefactor paying the lawyer, who knows who pays the lawyer for an objection, um, is the one that's actually trying to do what the election code allows them. So, at this point, I think there's a serious First Amendment challenge. I think it's a very sometimes the election code is very burdensome, especially on independent candidates, where they have a 15 times signature requirement. So, do I think that's fair? No. Is that consistent with the First Amendment guarantees provided by the U.S. Supreme Court? No, because it is an excessive, and the reason why I mentioned independence is because Illinois has not had independent elected officials, and there's very few independent candidates that have ever actually made the ballot. And so the burden is too high, and it's too high because of the historical record to show most people can't make this. Even diligent candidates can't make the ballot. And so we have to lower the number for independent candidates. I think that's my opinion. That's where the First Amendment hits the hardest, because there's not an ability to even make it to the ballot. And if you can't make it to the ballot, the voters don't even know, and they can't even have a chance to vote for you. So yeah, that's a denial of First Amendment rights.
Wow. You mentioned, are there any challenges? Do you see interest to, I'm probably answering my own question, but do you ever see a situation in which maybe they might change the law?
Yeah, when there's a political will, then the law gets changed. And it's not so much that working people or voters come up to their representatives or senators and say, hey, can you make it a little easier or a little bit better or a little fairer? It's a matter of self-interest. The 90-day provision that everybody has to gather their signatures under, that was brought about in the 83 or 85, not because people wanted a limit to the number of days they can circulate, but it was because the elected officials in Springfield were worried there wouldn't be enough voters left when they came back to their districts and tried to circulate their own petitions. So there's no real need for 90 days, but that was what was enacted. The CTU recently tried to enact the change that got rid of this, what's called the dual circulator law. There's a rule that says if a person circulates a petition for a Democrat or a Republican on the primary, and the primary is not an election. The primary is a publicly funded nomination process. It's no different than a caucus. And so the party picks its candidate, and the candidate has a very, very small, low signature requirement. So very low showing from the community to get on the primary. And then that candidate that prevails automatically gets put onto the general ballot. Well, this dual circulator law was potentially impacting Chicago Public School Board candidates, because there was a lot of people that were circulating for Democrats or Republicans, and then they started circulating for the CPS board members this last election. Well, there were proposed amendments it was called a gut and replace, and they took a Central Management Systems bill that had been tabled from 2025. They got Senator Harmon involved, and they gutted it at the end of May, just before the session ended. And they tried to there was two versions I saw of a potential change where they deleted the dual circulator, and then another one where they said, oh, except for school board, then the dual circulator, would apply. But that one did not pass. But that's the way the election code is revised. Literally, it's revised. And then the past 2 years ago, there was a faithful elector law. Same thing. It was a Crohn's Awareness Act that had been tabled. Okay, they had an act, Crohn's Awareness, and it was sitting for a year in a committee somewhere. So they got it. They take out the word the, and then they put the word the back in, and then they do another one, gut and replace, and they take this act is everything is deleted and replaced with the following, and then they enacted a 100-page election code change. Is that fair? Well, no. Is that legal? Not technically, but that's the way the election code has changed on a regular basis.
So, this is a good way to round this up. So, if voters are not seeing the candidates that they want to see, they understand there seems to be a growing sentiment for non-party, independent candidates on both sides of the aisle, so it seems. And when they go to their ballot, they see the same names, same people. What should voters do if they know that this challenge exists, this hurdle for independent candidates to surmount in order even just to make the ballot? What is something that voters should either A, be mindful of, or B, should do in order to make this a more accessible process for independent candidates to access the ballot?
Well, the most effective, I think, option would be for voters to come together and organize so that there is some unity and cohesion of the independent, voters and perhaps people who are looking for change, and then organize a letter writing or email or contacting their state rep and their state senator, because the state rep and the state senator are the two people that can change the election code. And that's I think the effective way. So if the state reps and state senators start receiving volume of email or messages to say, hey, we really want some reform. We really want to modernize the election code. We want to make it easier so that we have more candidates, not fewer candidates. Then maybe they'll start, taking some action. The other obviously thing is money and support, showing support with for certain candidates versus other candidates. But that's it's a good question. I think that's the real crux of how do you motivate voters. So we do have a growing number. I think the recent polls showed probably what is it about almost 50% of voters, okay, consider themselves to be nonpartisan or independent. So that means it's about 25-25 Republican Democratic. So, and then about almost 50% are independent. Now that's the voters, and voters are perhaps 60% of the population or so, depending upon how active. Some people register but don't do anything. But if you count people who are not registered as being independent, because if they're not registered, they're not political. If they're not political, they're not part of this partisan, process. So that means voters can, the independent voters would be well over 50% of the population as a whole. So it's a growing movement. How to motivate voters has been the challenge for political parties and candidates for 100, 200 years, 1,000 years. You have to have that right message, the right delivery. You have to have people on the street to promote the message. I think those are the three things, the right message, the right person, and then the people on the street to promote it. It's not an easy undertaking, and I don't know the exact answer.
Yeah, just to follow up, and do you think this challenge process is a reason why we always see the same candidates?
Oh, I definitely think that. Yeah, because there's so the challenge process is largely not all of the time, but a lot of the time it is motivated or supported or operated through the partisan network, Republican Party, Democratic Party, and their corresponding attorneys that generally work for those parties are the ones that are bringing the objections. And, I mean, sure, if somebody has a ton of money, they can get on the ballot no matter what, because, you put in enough signatures. I think when Rahm Emanuel first ran for mayor, he had over 120,000 signatures. And, even though the number for Chicago mayor is 12,500, which is a huge number, okay, but, he overwhelmed the signature number. So there's no way, anybody could have challenged him. So that's the way to overcome this system. But here's the kicker. So independent candidates, have a limit. It's 5% to 8%. And it's not just of the party's vote. So it's very complicated on calculating some of this stuff. And I don't know if you want to get into the details,
We
but
don't have to get
it's
into that.
okay.
We don't
It's
have to get into that.
right. So, but it's the independent candidates are limited by the maximum too. So that means that you would have to spend a lot of extra time at the board of elections, whether it's the state, the county, the city, looking at signatures. Because as you noted, and you correctly pointed out that signatures are only available for review at the office. So between 9 and 4:30 or 9 to 8 to 5, whatever the office hours are open, Monday through Friday, you can have your team looking at the signatures, and then you can take out the ones that don't match. But that's another big time consuming component. It's a real, I think the election code needs to get revised. The only way to really do it is either through a court process where you can piecemeal knock out certain parts, which it's not very effective because the laws are all presumed valid. But the quickest way is through the legislature, and Don Harmon knows how to do it. Senator Harmon, if he wanted to, could change a law in 2 or 3 weeks. But if you get Speaker Welch on the case, it's a done deal. They could change the election code overnight if they wanted to.
Yeah, but it benefits them. Um, well, thank you so much. I really appreciate your time. Would love to have you back as we get closer, further into this cycle after November. But I think this is a really good start for folks.
Okay, thank you.
All right.